जो वर्डिक्ट चल रही है, अदालत के बाहर हम अदालत लगाएंगे। तो आज पूरा ये लाइव वीडियो जस्टिस सूर्यकांत का आप देखिए। तो अब अभी पूरा लाइव वीडियो क्या हुआ सुप्रीम कोर्ट में जस्टिस सीजेआई के साथ, किस किस ने दलील दी, जो सीबीआई के वकील हैं उन्होंने दलील दी, लेकिन इस प्रकरण में एक आए हैं महमूद प्राचा आए हैं, उनको बहुत जबरदस्त फटकार लगी है सुप्रीम कोर्ट की तरफ से। लेकिन पूरा पहले वीडियो देखिए।
Framed during the trial on two broad offenses, section 376 of IPC and section 5 and 6 of the POCSO Act.
376 IPC
376 IPC
and
section 5C
5C of the POSCO Act,
within brackets
376(1).
Only a minute, sir. Sir, I'll say everything truthfully. The charge is framed under 376. I'm, my lord, consciously making, my lord, my submissions, my lord. Now, when, my lord, the conviction is recorded, the conviction is on two counts. My lord, I can, my lord, just for easy reference, I have quoted, my lord, the relevant part of whatever I am, my lord, relying upon. This is, my lord, the order of conviction in para 3. Please have a look, my lords.
paragraph 3.
Paragraph 3 of this note. But this is my note. What are the infirmities in the impugn order, my lords?
In view of the
This is, my lord, the trial court's conviction in view of the
aforesaid discussion.
In view of the aforesaid discussion, I find that prosecution CBI has been able to prove the guilt of accused Kuldeep Singh so-and-so beyond a reasonable doubt, and therefore he is convicted under section 376 IPC, please mark this, and section 5C and 6 of the POSCO Act. My lord, now I'm not touching, my lord, 4 because which I have said that there is a trial conducted. There is a finding recorded that the child was less than 16. My lord, to be precise, 15 years, 10 months and 13 days as my lord held by the trial court's order, and we will have to, my lord, as of date, go by what the trial court's factual finding is. My lord, the appeal is pending. Now, there is an order of conviction.
Against this conviction, appeal is pending.
Appeal is pending, my lords. So right now, my lord, so far as the child...
Adding to your assistance,
Yes,
page number 211,
yes,
when the sentence was pronounced, para number 13 and para number 14,
yes, I'm grateful.
where 376 to I has been dealt with.
Correct. I'm grateful, my lord. I'm relying upon it, my lords. My lord, kindly see, then, my lord, page 2, para 5. I'm grateful, my lord. At the time of sentencing on 20th December, the trial court convicted the accused under section 376(2) of IPC in light of section 376(2)I, which was undisputably on the statute book on the date of the offence. Now, my lord, what is that 376? My lord, before I take your lordship to this, my lord, 376 has two parts. 375 is definition of rape. He is convicted of rape. There is no doubt about it. 376(1) says that if you are convicted under 376(1), then the punishment would be minimum 10 years and maximum life. There is an aggravated form of rape. Lord, if someone who is in a dominant position,
There are 4 or 5 illustrations given.
illustrations,
Like in police station, suppose it
a police station or someone who is a family member,
Or-
who has a dominant position,
Yes.
etc.
or in an institution, public institution.
Public institution, my lord, orphanage, etc. Lord, then the punishment is minimum 20 years, and it can go up to your biological life. Lord, I, subsection 2, subclause I says, commits rape on a woman when she is under 16 years of age. Then dominance not necessary, nothing is necessary. If she is 16 years or less, then it would fall
And
under
independently, it falls within the mischief of 376 to I.
2I. And therefore, the punishment will be
20 years
minimum
minimum.
20 years and
or
maximum
can be
up to
life.
biological life.
That's it.
My lord, here the court, my lord, convicts him under 376(2)(I).
Assuming that the victim is not a minor, in a case where the victim is raped but not a minor, still the minimum sentence of 371 in any case will be there,
will be up life.
will apply. That will be minimum 10 years. It can go up to 20 years.
Yes,
This
Right.
is also minimum
Yes.
10 years.
life.
2 is also minimum 10 years, not 20.
Two is minimum 10, but what is awarded
To
is
that extent, he is right. You are right.
Yes.
To that
Yeah,
extent,
he's right.
To that extent, you are
10
right.
years.
the amended, he's right. As it stood then, now it is, my lord, amended that it should be minimum 20, but we are not concerned. Minimum 20 and it can go. Here, my lord, the court has said till your biological life.
Right, sir. The minimum point is the offence is committed on 4th of June 2017. This amendment has been brought subsequently
18.
on 21/4/2018.
18.
So on the date of commission of the offence, whatever the situation.
I was
is
there.
I was there.
Yes,
All right, when the I was there on that day, then it will be read as it is, whatever the situation.
absolutely.
And when the suspension of sentence was directed, you directly come to the page. Come to the page number, para number 30.
Yes, my lord.
Come directly, we'll let you know this, brief it, everything.
My lord, page 215.
Yes. Then where they have only been dealt with, come to page number, internal page 37. Para 30, last line. They have dealt with of 376(2)(B without dealing with 376(2)(I). That is the crux of the matter.
Lord, as a matter of fact, your lordship comes to page 25, para 25 of the impugn order. My lord, please come to para 25 of the impugn order. My lord, that is more, my lord, erroneous. Page 30, my lord. Kindly, my lord, for my satisfaction, come to page, para 25, page 30.
Yes.
Para 25. The learned trial court has convicted the appellant for the offence under section 376(2) of IPC as well as section 5C punishable under section 6 of POCSO Act. For the purpose of present application, this court turns its focus to the appellant's conviction under the POCSO Act only. So 376, whether 1 or 2, it is life or biological life. That's the only distinction. But life is the minimum in the facts of the case. No, that's not considered.
Life
And the
is
court,
not the minimum.
only a minute, sir. And the court says, now 7 years, you are not a public servant. So you fall and, my lord, I have another argument, my lord, on POCSO Act also, because my learned friend could argue on that.
Is it your argument that the concept of being a public servant
Yes,
is completely alien and irrelevant when the victim is a minor?
absolutely. Now kindly, my lord, take the POCSO Act, where, my lord, there is a legal, what has gone wrong. No, please kindly have a look at, my lord, the POCSO Act. My lord, POCSO Act offences can be broadly classified in 2 categories. Broadly. One is penetrative sexual assault. It's per se an offence. My lord, section 3.
Section 3.
Section 3. Assault is an independent offence. Now 4 provides for the punishment. My lord, prior to the
Amendment.
amendment, my lord, which came after the offence was committed.
2019 amendment.
Yes, my lord, 2019, my lord, it was after the offence in, but my argument would be, it doesn't make any difference. I'll come to that. It was, my lord, not less than 10 years and which can be life. Earlier, it was 7 years. Now, my lord, there is a separate category of offence. The same offence, my lord, which is penetrative sexual assault, but in certain circumstances, it is aggravated form. Aggravated based upon the person who commits the offence. And if you go by, my lord, the nocitoro socis doctrine or, my lord, the egestem generis, my lord, the categories are that if a person is in a dominant position over the victim, then he is considered to be an aggravated form of offence. Please have a look, my lord. Whoever being a police officer commits penetrative sexual assault on a child within the limits of police station, in premises of any station house, in the course of his duties or otherwise, or where he is known as or identified as a police officer. My lord, kindly take an example of 5A3. In the course of his duty, a constable is a category, my lord, who, if commits an offense, would be in the aggravated form. Kindly bear that in mind. Then B, whoever being a member of the armed forces or security forces commits penetrative sexual assault on a child, my lord, the same, but 3, in the course of his duty. So if an SRP man is there, my lord, in the security of a member of parliament or a member of legislative assembly, he would be guilty of aggravated penetrative sexual assault. Now please see C. Whoever being a public servant commits penetrative sexual assault on a child. My lord, my respectful submission is, my lord, public servant is not defined in this act. It is, my lord, defined as borrowing, my lord, or definition by reference, that whatever is defined under the IPC would be the definition. But the important question of law would be, section 2 starts with unless context otherwise requires. My lord, every word used in any statute is not mechanically getting the definition. If the contextualized definition is to be considered, then public servant would mean a person who is in such a dominant position over a child, because POCSO, Lord, deals with only children.
So according to you, in the legislative intent, in a kind of a non-obstante clause in section 2 opening, where
Yes.
it says unless the context otherwise requires.
Yes.
The expression public servant is a very broader term.
Broader term.
It's not necessarily for the purpose of public servant. Say you treat an PC Act or under
Or IPC.
IPC.
Yes.
Here it is public servant is that who is in a dominating position
Yes.
in a particular factual background of a incident that is.
Particular case. In this case, he was MLA of that area, a very powerful MLA, and the girl
If a
was 15.
representative comes, if a public representative comes to MLA and seeks any kind of help, assistance for any, say, public duty, and there if we misuse that dominance of being a public representative, then this is your argument that such an act will fall within the ambit of
Public servant.
misconduct by the public servant.
Aggravated form of.
Aggravated form of.
Otherwise, kindly see the incongruous position which arises. I am a member of parliament. My lord, I will have, my lord, one police constable as my security person. He would be a public servant for the purpose of, my lord, section 5. I will not be a public servant. Why? As per, my lord, the argument of the accused, because in A.R. Antule case, the Supreme Court has said that member of legislative assembly is not a public servant. But that was in a fact-specific situation. But what happened was, Mr. Antule was a chief minister when the offense was registered. So he was a public servant. Thereafter, he had to tender his resignation, and therefore he ceased to be a chief minister, but continued to be a member of legislative assembly. When the charges where cognizance was being taken, he raised an issue that this is a offense under Prevention of Corruption Act 1947, which did not have the definition of public servant. And therefore, no cognizance can be taken against me unless you have a sanction.
Exactly. So at that time, probably the member of the legislative assembly were not considered in public servant definition under
Yes.
the old act.
So the court, my lord, construed that provision in the context of Prevention of Corruption Act, and against him, that no, you may not be a public servant. You are MLA, and therefore you need not have a sanction, and you can be proceeded. That law will not apply if we interpret this public servant.
See the relevance of the context otherwise required. There the court did not want to grant him the protection of not being a public servant for the purpose of prosecution under the PCA.
Exactly, PCA.
Therefore, court said,
Grateful.
even if you are not a public servant, you are still able to be prosecuted.
I'm grateful, my lord.
So that was in that
Yes,
context.
my lord. Now, my lord, my third submission. My lord, suppose he is not a public servant for the sake of argument, my lord. I presume he doesn't fall within 5C. He would definitely fall within 3. Because it is, my lord, an aggravated, it is a penetrative sexual assault. That is the finding recorded.
Minimum
Now-
7 to end life.
Yes.
Minimum 7 and life.
Now, my lord, 4. My lord, the argument is this, and kindly see, my lord, this is, my lord, the very nuanced argument which, my lord, I am placing for your lordship's consideration. When the offense was committed, penetrative sexual assault was an offense. I am on Article 20 argument. It was punishable by 7 years. Amendment does not create a new offense. It merely enhances the punishment. Instead of 7 years, now it is life. So when existence of an offense is not in dispute on the date on which the act under section 3 is committed, mere enhancement of sentence subsequently by the legislature would not fall foul of Article 20. There are judgments to that effect. You cannot have a new offense. The reason is this: when I am committing some act, but not any act, then I am presumed to know whether that act is illegal or legal. At the time when I commit that act, if that act is not an offense, then I cannot be punished. So new offense cannot be created retrospectively by the parliament or by the legislature.
Maybe that your argument probably it can be that there is an offense defined on a particular date when the incident takes place, occurrence takes place. That is, let us say in 2017.
Yes.
In 2019, when the amendment takes place, the amendment does not obliterate the offense. It does not erase the offense. The offense continues to be an offense.
Yes.
The legislature makes rather intention very clear that this offense we are treating very serious offense. It is offense against the very ethos of the society, and therefore we are enhancing the sentence. We are enhancing the sentence. So when the court is examining, after somebody is held guilty, if he is found guilty, he is convicted.
Yes.
And when the question of sentencing comes, the court will see what is the growing trend. The growing trend is that the legislature wants it to be more harsher and want to send a kind of a very deterrent and a befitting response, keeping in view the very cruelty and the extreme
gruesomeness of the offenses.
The court, even under the old provision,
It was
when considering that whether it should be a case of minimum sentence or it should be more than minimum sentence.
But
So sentencing part, it
the
can be.
logic behind Article 20 is, well, not suppose I am committing an act today, any act, which is not a penal offense. I can say that, but I didn't know that this is an offense. Therefore, you cannot create a new offense. But when I am committing an act, it is an offense. Lord, can I say that I committed an act because I knew that it is only
It will
7
apply to
years?
reverse also. In a case, suppose there is an offense in 2017 and 19 legislature says it is no longer an offense.
Correct.
The court can keep in mind that he is guilty of a technical offense, which is today no longer an offense. Therefore, I should award him the minimum one. That is
That can be a consideration for sentencing.
mitigating circumstance, one of the mitigating circumstances for the purpose of
Sentence.
evaluating the quantum of